First of all, we need to consider the science, and the question of what constitutes a foreseeable risk of harm in 2024 is very different from what was foreseeable years ago, when much of the asbestos exposure actually occurred. In order to consider fully the question of what constitutes a foreseeable risk in common law and in accordance with statutory duties, it's necessary to consider the development of scientific knowledge, which quite often develops in a uneven or haphazard fashion from the early 19th century onwards. We also need to look at the role of HMFI, Her Majesty's Factories Inspectorate, when we consider the development of knowledge of the risk of asbestos-related disease. This is going to be relevant later on when we consider the approach the courts have taken in respect of the foreseeability of harm in low exposure cases. To give you a context of how far the Factory Inspectorate goes back, the first Factory Inspector was appointed by King William IV in 1833, with the first medical inspector being appointed in 1898. The judge in this particular case stated that the permissible levels identified within the toxic substances document provided reassurance to the defendant that the levels of asbestos dust to which the claimant was exposed gave rise to no risk of injury. And further, the judge went on to refer to the Newhouse and Thompson document, which was published after the exposure in this particular case, and stated that it was not until after the publication of this document, at the earliest, that employers could have been aware that asbestos exposure to the levels at which the claimant was subjected to gave rise to risk of injury.